Hi, my name is CoColaxxative. I'm a senior attorney and founder of Spooky Law Offices, and this is my class about legal practice and tactics and the basics of litigation. So today we're gonna study a bit about real usable tactic strategies you can use in courts. So the very first thing you're gonna need on the basics of litigation is knowing your docs. I know it's a bit boring to have just five walls of text, but you need to know that. Here I've included a link to both the Montroigan and Olarashi rules of judicial procedure. They are basically the same. There's a few differences you need to identify. The docs for motions and objections, which is very important, and your best friend whenever the opposing counsel is speaking, and the code of law of Montroig. Obviously, if you are prosecuting or defending in another country, your mileage may vary. You may need to use the laws of this country. So, once you know that, I'm just gonna a quick reminder about trial steps. Preliminary hearing is basically when the plaintiff goes to the judge and says, "Hey, here's what I filed suit for. We agreed on the date. We have the accused who pleads guilty or not guilty, and then if we proceed to trial, we go to discovery, which is when everyone just gives their evidence beforehand. After you have the time to just check the evidence and review it and prepare a case, you are summoned to the court, which is you go and sit on your seat. Then there's the opening statements, where you just declare what you're gonna do. You basically make the introduction of an essay, but without argumenting in any way, just like your three-step plan. Here's what I'm gonna do. The case in chief, which is the big part of your entire process, where you're just gonna go and call your witness to the stand, then examine them, and then present evidence, and then plead to the jury or the judge, and then just say, here's what I think happened, here's why my client is guilty or innocent, here's my client is not guilty, here's why the opposite, the accused is guilty if you're prosecuting, etc. There's rebuttals, where you just go and say why the opposing counsel is wrong, you just present counter arguments. Then after that there's a rebuttals, which is the same thing but for rebuttals, etc. And then there's your closing arguments, where here you are allowed to just go and make your arguments and everything just neatly cite the case. That's your last piece of speech to the judge before the verdict, which is when they smack the gavel on their desk and say guilty or not guilty. So that's it. We're gonna talk about biases. I put, by the way, this Google Slides will probably be available to you. You can ask me. I'll probably put the link somewhere. So the biases are flaws in logic that are natively present in our brain as a result of either conception or evolution or etc. diverse reasons and or conditions in our society. And that's a little thing you need to know. It will be useful also in other domains of your life, not only in the court, but it's particularly useful to know this on the court. So here's a few examples on the left. Curse knowledge is the bias in which when you know something, you assume other people know it too. Confirmation bias is you accept evidence that supports your worldview easier than other ones. Framing effect means that the better something is presented, the most likely it will convince people. And anchoring bias is the fact that you remember, or the first thing sets expectations. So you remember better the first word of a sentence, for example. On the right, you have this zero position effect, which we will talk more about in the strategy section. So, logical fallacies are also are related to biases, but not exactly. Sometimes they use biases as the way to do it, but it's basically arguments that are fallacious in nature, which do not hold under scrutiny, but which may seem acceptable to the untrained eye. So a strawman argument is when you misrepresent the arguments of your opponent in order to have an easier time countering. The burden of proof, as you all know if you're studying law, is the fact that everyone is innocent until proven guilty, at least in court. The law's question is a question that is made to make the opponent look bad. So, for example, if you ask, reply by yes or no. Have you stopped beating your wife yet? Whatever the subject replies, he'll still tacitly admit to have beaten his wife. That question itself assumes or pretends something about the scenario. And the Texas sharpshooter, you may have heard it referred to as cherry picking, is when you take the bit of evidence that goes your way and ignore all the rest. So next to them, I've made specific objections that generally apply. So you may want to go to the motion objections on the second slide and then check the objections in general. Objections are extremely useful. Just check them. So now we're going to talk about the trial advocacy, which is how to use what you learned in an actual court. So here's the two basic litigation strategies. The difference between a strategy and a tactic, very subtly, is a tactic is on the short term and a strategy is on the long term. So, say for example, playing chess, how you're gonna make your opponent prevent your opponent from castling, or try to isolate his king, or how you're gonna plan to play your endgame is strategy. It's the long term, or the opening you do. But however, putting your pawn, one case, making your pawn go to a specific place so that your opponent is forced to move a piece, that's a tactic. It takes 1 or 2 turns and it's very short term. So on the left you can see the OODA loop. The OODA loop stands for observe, orient, decide, act, and it's also called the Boyd loop over this creator, return Boyd. So the OODA loop is used in many situations where you need to react to a change in the enemy's plans, and it's here basically as an aid. The very first rule of trial is don't lose your patience, be calm. And the OODA loop is very helpful in that regard because you know what to do. So first of all, if your opposing counsel pulls something crazy, so just the witness says something that he didn't know he knew, or this piece of evidence actually is invalidated, or anything that derails, just calm down, observe the situation, orient, which means reduce the number of possible actions you can do to a few, and then decide which one you're going to take, and then you can act. You can always ask for a recess to the judge in general, except if you need to speak to your clients, or if you need time to examine evidence or something. You generally can ask, and they will. And then on the right you have the zero position effect, the great return. So you can see that's basically an excerpt from a study where they took people and they just gave them a list of random words that have no relation to each other, like door, noodles, elephants, etc. And then they said write down whatever you can recall. And this is the probability of recalling a word by the position of the item. So they tend to recall the first bits, and then they tend to recall the last ones, which because basically the first things, because of the anchoring bias, if you remember, enter their long-term memory faster, and then the last bits obviously are still fresh in their short-term memory. So we can use that as if you know that you know how you're gonna how there's a basic strategy which is just to use this fact to orient your decision making. If you're a prosecution, you have the interest that the primary effect be as strong as possible on the judge or the jury. So what you're going to do is try, in your case in chief, to try and make big waves. Present your best evidence first. Try to shock a bit the audience. Try to make it bigger than it already is, so that they remember it better. Humans tend to remember things better when there's a strong emotion attached to it. So arguments well, use appeals to emotion, etc. So you can present your case very, very well. And then if you're the defense, obviously you're not going to want to let the prosecution do that, but you also want to use the recency effect to advantage. So the best thing about your defense should be your closing arguments, because that's a thing you can do. You can just speak to the judge or the jury freely while argumenting, and then the prosecution doesn't get to answer to that. So, and it's better remembered than whatever the prosecution said just before. So you can just go down with it and make it make it not too long, but decently sized. So thank you very much for your attention. You can still DM me or ask me in university chat if you have any questions. There will be an exam on all this, so I advise you to just read everything I sent once from the websites and the links I made to other docs. The exam will be held next week. I don't know when exactly, but it's probably going to be next week. And if you can't attend, I'll make several sessions, but I'm going to so you can just check the response. So you can just take the answers from your friends, and that's basically it, I think. Oh yes, you also have the right to use any and all documents while you do the exam. There's going to be 5 questions on this course, and then there's going to be most of the grades going to be graded on basically a fake mock case that you have to prosecute or defend. That's going to be it. So next week. Thank you very much for your attention, and good luck in your legal enterprises.